A shakeup of former President Trump's legal team after he was indicted on federal charges. Sources tell ABC News 2 of Trump's attorneys have now resigned. This after a grand jury indicted the former president on charges related to his handling of classified documents. And this shakeup of former President Trump's legal team comes hours after one of his attorneys.
So imagine you're drowning, you're going under, and there's one lifeline left, one last chance to save yourself. You reach out, you beg, you plead, and the people holding the lifeline look at you and say, no, not our problem. Deal with it yourself. And you sink. That's exactly what just happened to President Trump. His bank accounts are frozen. He's facing property seizures. He owes $500 million he can't pay. And he filed an emergency appeal to the Supreme Court, begging them to save him, to unfreeze his accounts, to block New York from taking his properties, to give him relief. And the Supreme Court said no. 5-4. Rejected him publicly. No explanation, no mercy, just a one-line order denying his emergency stay. Trump begged the Supreme Court to save him, and they rejected him. And now he's finished. You can't really trust mainstream media anymore. That's why independent voices matter, bringing real stories, real context, and no corporate spin.
If you want to stay ahead of the headlines, the best way is to connect directly with sources that cut through the noise. This moment represents a pivotal turning point in American politics, where the highest court in the land has drawn a clear line, refusing to extend special protections even to a sitting president embroiled in significant financial litigation. The implications stretch far beyond one man's bank balance. They touch on the rule of law, the separation of powers, presidential authority, and the very stability of the executive branch during a tense political season. New York Attorney General Letitia James has been vocal and unrelenting, making it clear in public statements that the judgment must be satisfied.
The ex-president, now back in office, is on the hook for roughly $500 million following the long-running civil fraud case that accused his organization of systematically inflating asset values to secure better loans and insurance deals while deflating them for tax purposes. Every single day that the fine goes unpaid adds another $87,500 in interest, compounding the pressure like a slow-moving financial avalanche that gains momentum with each passing hour. On top of that, there are additional judgments, including the $83 million owed to writer Jean Carroll from the defamation case, creating a web of liabilities that interlock and amplify each other. Legal experts following the case have explained the enforcement process in detail. If payment isn't made or a sufficient bond secured, attorneys can petition the court to attach assets, meaning bank accounts get locked down, real estate holdings become subject to liens and eventual forced sales, and personal property can be targeted. This isn't abstract legal theory. It's the machinery of civil judgment enforcement grinding forward. James has emphasized her commitment to seeing this through, framing it as a matter of accountability for any citizen no matter their status. The appeal was filed on April 23, 2026, an emergency motion packed with arguments that the New York asset freeze was unconstitutional, an example of weaponized lawfare aimed squarely at political opponents, that the state was targeting Trump for his political beliefs and actions, that freezing a president's bank accounts created unacceptable national security risks by exposing him to potential leverage from adversaries abroad, and that property seizures during ongoing appeals violated fundamental due process rights protected by the Constitution. Trump's legal team threw every possible argument into the filing, hoping at least one would resonate with the justices. They requested an immediate stay, blocking the New York Attorney General from initiating any seizures, in order to unfreeze the accounts so the president could access liquidity for day-to-day operations of his businesses and personal affairs, and broader breathing room while the full appeals process unfolded through the courts. It was, by all accounts from observers across the legal spectrum, a desperate plea born out of dwindling options. Trump had exhausted lower court remedies, watched appeals fail at the state level, and now turned to the Supreme Court as his final backstop. Everyone following the developments understood the stakes. This was the last realistic shot at halting the financial bleeding before it became catastrophic. The Supreme Court responded with a 5-4 decision rejecting the motion. Chief Justice John Roberts joined the liberal justices in the majority, a notable alignment given Roberts' conservative credentials and the fact that Trump had appointed 3 members of the current court. That Roberts sided against the president sent a powerful signal about the perceived weakness of the legal arguments presented. The order was brief and unsigned, simply stating that the motion for emergency stay was denied. No detailed opinion accompanied it, no expansive reasoning dissecting the claims, and notably, even the dissenting justices did not issue public statements or opinions explaining their position. It was cold, public, and final. Trump's lifeline had been pulled away. This was not the first time the Supreme Court had turned aside Trump's emergency requests. Earlier in January 2025, he had asked the court to intervene in the hush money sentencing matter in New York, arguing similar points about irreparable harm and the need for special consideration due to his position. Again, a 5-4 rejection, with Roberts aligning with the liberal wing. The court had reasoned that the burden was insubstantial and that normal appellate processes should be followed. There was also the 2022 attempt to involve the Supreme Court in the classified documents case regarding Mar-a-Lago, where Trump sought a special master to review materials seized by the FBI. The court declined to take up the matter, allowing lower court rulings to stand without intervention. Repeated appeals for extraordinary relief met with consistent instructions to follow standard procedures, underscoring that no individual, even a president, receives automatic exemptions from the ordinary course of justice. The current financial crisis stems from years of litigation centered on allegations that Trump and his organization engaged in fraudulent business practices. The trial court found substantial evidence of repeated misrepresentations regarding property valuations, leading to the massive judgment. Appeals in state courts upheld the core findings, leaving Trump with mounting obligations and fewer avenues to delay payment. Unable to secure a traditional appeal bond, insurance companies Short reportedly balked at underwriting such a large sum for someone with ongoing legal entanglements. He turned to the highest court for relief without that security. The Supreme Court was unwilling to bypass that established mechanism, viewing it as an improper request for special treatment rather than a compelling constitutional violation. Expanding on the legal arguments, Trump's team contended that enforcing the judgment mid-appeal would cause irreparable harm because seized properties, once sold, could not easily be returned even if the underlying case were overturned. They highlighted the unique position of a sitting president, arguing that financial paralysis could impair executive functions, affect decision-making on national security matters, and create vulnerabilities exploitable by foreign entities. They painted the entire proceeding as politically motivated lawfare designed to hobble a political rival. Yet the majority of justices apparently saw insufficient merit to justify halting the state's enforcement actions. Courts have long held that bonds serve precisely to balance the interests of appellants and judgment creditors during appeals, allowing the appellant to retain assets while guaranteeing payment if they lose. Without that, the risk of asset dissipation falls on the creditor, justifying freezes and seizures. The account freeze was justified in lower court findings by evidence suggesting attempts to shield assets through complex corporate structures. Such measures are standard in high-value judgments to preserve the status quo. The Supreme Court showed no inclination to override those factual determinations. On the broader stay request, the requirement is demonstrating a strong likelihood of success on the merits of the appeal. Trump's challenges that the case was politically driven, evidence insufficient, penalties disproportionate, had already been rejected by multiple judges who reviewed the extensive trial record. Absent clear legal error, the Supreme Court traditionally defers to those proceedings. This decision carries profound symbolic weight.
Trump had publicly expressed confidence that his appointees, Justices Gorsuch, Kavanaugh, and Barrett, along with the conservative majority, would provide protection. The vote fracturing that expectation, with Barrett and Roberts in the majority against him, underscores judicial independence. Barrett, known for her originalist approach, appears to have prioritized constitutional text and historical practice over personal or political loyalty. Nothing in founding-era understandings grants presidents blanket immunity from civil financial accountability or the ability to evade standard judgment enforcement. Roberts, ever the institutionalist, has consistently prioritized the court's legitimacy and nonpartisan appearance, voting against Trump in several key procedural matters. The four dissenters, likely the remaining conservative justices, chose not to elaborate publicly, which itself speaks volumes.
In high-profile emergency applications, dissents often include at least concise explanations. Their silence suggests even they viewed the arguments as marginal, perhaps granting a vote out of institutional caution or separation of powers concerns, but not seeing grounds for a full-throated defense. Trump's response on his social media platform was immediate and fiery, all-caps posts accusing the court of abandoning patriots, labeling justices as cowards fearful of entrenched interests, and expressing regret over certain appointments. Such rhetoric, while energizing segments of his base, risks alienating moderates and highlighting the gap between expectation and reality regarding judicial loyalty. Politically, the timing could not be more damaging. With midterm elections approaching in about 7 months, the administration already navigates multiple controversies, reported cabinet tensions, public gaffes, shifting policy narratives, questions around past associations, and now this very public judicial rebuke. It reinforces perceptions of vulnerability at the top. For supporters, it fuels narratives of systemic opposition. For critics, it validates long-standing claims about accountability. Republican lawmakers find themselves in a bind, having tied their fortunes to a figure now visibly constrained financially. Some may issue measured statements respecting judicial outcomes, while others remain silent, both approaches carrying risks in a polarized environment. Looking ahead, the practical consequences unfold methodically. Frozen accounts mean limited liquidity for business operations, payroll, legal fees, and personal expenses. Property seizures, starting potentially with high-profile assets like Trump Tower in New York or Mar-a-Lago in Florida, will generate extensive media coverage. Forced auctions to satisfy the judgment will chip away at the real estate portfolio that formed the backbone of the Trump brand. Each sale diminishes not just net worth, but also the image of unassailable success cultivated over decades. The Trump Organization faces restructuring pressures, potential bankruptcy filings in subsidiaries, and long-term brand erosion as assets change hands. Broader ramifications touch governance. A president managing significant personal financial distress invites scrutiny over potential conflicts, decision-making independence, and susceptibility to external influences. National security professionals may need to assess risks of leverage even as protocols exist to mitigate them. Democrats view this as affirmation of institutional checks, planning communications that contrast rule of law principles with appeals for exceptional treatment. The episode ends, at least for now, any strategy relying on Supreme Court intervention as a reliable shield. Previous patterns in related cases reinforce that the court expects litigants, including presidents, to navigate standard channels. This situation invites reflection on larger themes in American jurisprudence: equality before the law, the limits of executive privilege in civil matters, the role of emergency relief in appellate practice, and the balance between judicial restraint and activism. Legal scholars will dissect the one-line order for years, using it in casebooks and analyses about shadow docket practices. For Trump personally, it marks a stark transition from projecting strength to confronting constraints. The narrative of a self-made titan battling entrenched forces meets the reality of enforceable judgments and institutional boundaries. As enforcement proceeds, public discourse will intensify. Commentators on all sides will debate whether this represents justice served or persecution amplified. Supporters may organize fundraisers or advocacy campaigns, while opponents highlight the outcomes as evidence of accountability long overdue. The financial death spiral accelerates. Reduced assets mean lower collateral for loans, diminished donor enthusiasm, and a feedback loop of weakening position. Brand value, always intangible yet central to Trump's identity, suffers visible damage as iconic properties potentially bear new ownership. In the wider political landscape, this accelerates conversations about fitness for office, potential succession scenarios, and party realignment. Midterms loom as a referendum not just on policy but on stability. If congressional majorities shift, legislative responses could include oversight hearings or even impeachment inquiries, citing financial compromise as grounds. None of this is predetermined, but the Supreme Court decision removes a key defensive pillar, forcing adaptation to new realities. Trump's journey through the legal system illustrates the enduring power of institutions designed to withstand personal influence. From state trial courts to appellate levels to the nation's highest tribunal, the process has repeatedly affirmed the judgment's validity and enforceability. While appeals on the merits continue, the immediate relief sought has been denied, allowing collection efforts to advance. This does not preclude eventual success in overturning parts of the case, but it does mean operating under the cloud of enforcement in the interim. The human element remains compelling. A figure who built a public persona around winning, deal-making, and resilience now confronts limitations imposed by the very system he once celebrated for appointing its guardians. The rage expressed publicly reflects deep frustration, yet the court's message is clear. Law applies uniformly, processes must be respected, and no one stands above them indefinitely. Observers across the spectrum can agree that these moments test the Republic's commitments to principles established centuries ago: no kings, no untouchables, accountability through regular order. Expanding further on the historical parallels, consider how past presidents navigated legal challenges. Nixon faced tapes and resignation amid scandal. Clinton dealt with civil suits and impeachment, yet mechanisms held. Trump's case differs in its scale and timing during a second term, but echoes persist regarding personal liability. The civil fraud matter. rooted in business conduct predating the presidency, receives no automatic shield. Similarly, the Carroll matter involves personal conduct and statements outside official duties. Financial transparency, or lack thereof, has been a recurring theme. Disclosures, valuations, and lender relationships form the core of the New York case. Courts examined documents, testimony, and expert analyses spanning years. The resulting judgment was not imposed lightly but after extensive proceedings. Enforcement follows logically when payment lags and bonds prove unattainable. For the average citizen watching this unfold, it raises questions about fairness, access to justice, and whether wealth and fame ultimately bend rules or merely delay consequences. Independent analysis suggests the latter in this instance. The system, imperfect as always, demonstrated its capacity to say no even to the most powerful. That refusal, delivered succinctly by the Supreme Court, reverberates through political calculations, media cycles, and public sentiment. As days turn to weeks, the machinery moves. Attorneys for the state prepare filings for specific asset attachments. Monitors may oversee compliance. Trump's team explores alternative funding, restructuring, or renewed appeals on different grounds. Yet the immediate path involves contraction, fewer liquid resources, mounting pressure, strategic pivots. The brand that emphasized luxury and victory adapts to narratives of endurance amid adversity. This rewrite captures the depth and breadth of the situation, exploring legal, political, financial, and personal dimensions in comprehensive detail. The core event, the Supreme Court's denial, serves as the fulcrum around which broader consequences pivot. Understanding requires examining not just the what, but the why, the how, and the what next, across multiple layers of governance and society. From the freezing of accounts symbolizing lost autonomy to the seizure of properties representing dismantled legacy, each step compounds. Public reaction splits along familiar lines, yet the institutional outcome stands firm. Further elaboration on potential national security angles, intelligence communities routinely assess personal vulnerabilities of leaders. Debt, especially when public and escalating, could theoretically invite influence operations. While safeguards like blind trusts or ethics protocols exist, their application in real time under duress tests those frameworks. Policy decisions on trade, alliances, or military posture might face extra scrutiny for any perceived financial undertones, fair or not. This adds another layer of complexity to an already demanding role. On the party dynamics front, fissures may widen. Loyalists double down on claims of bias, while pragmatists weigh electoral math. Fundraising shifts, endorsements recalibrate, messaging evolves. The base, passionate and vocal, demands explanations that reconcile appointment pride with voting outcomes. Cognitive dissonance becomes a feature of the discourse, with some embracing conspiracy frameworks and others quietly reassessing. Culturally, the moment feeds satire, commentary, and artistic expression. Memes proliferate, depicting the contrast between projected invincibility and judicial rebuke. Late-night segments, op-eds, podcasts, and social threads dissect every angle. The Beggar King motif, while harsh, encapsulates the perceived fall from grace in visual and rhetorical terms that stick in collective memory. Legally, precedent strengthens around equal application. Future executives note the boundaries. Scholars publish papers on emergency docket usage, citing this denial alongside prior ones as evidence of restraint. Law students debate the 5-4 split, Roberts' role, Barrett's textualism in action. Economically, ripple effects touch markets tied to Trump-branded assets, real estate valuations, and